Get ready. 3 seconds. 2 seconds. Start. By this petition, under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioners defendant in TS number 19 of 2018 have prayed for setting aside the order, passed by the Court of Learned Additional District Judge, Assam, in petition number 145 of 2019, whereby their prayer for rejection of the plain on ground of limitation was rejected. Para. The petitioners defendant cited 4 grounds to assail the impugned order. Firstly, that the learned trial court, while interpreting the provision of Section 3 of the Prohibition of Child Marriage Act, 2006, completely failed to take into consideration the relevancy and impact of the definition of minor as contained in Section 2 F of the Prohibition of Child Marriage Act 2006 and the provision of Section 3 of the Majority Act 1875, secondly, that the learned trial court, while interpreting the provision of Section 3 of the Prohibition of Child Marriage Act 2006, held that a male would be considered to have been attained majority only upon completion of 21 years of age, and thirdly, that the learned trial court failed to take into consideration the fact that as the repeal and saving clause of the Prohibition of Child Marriage Act 2006 in Section 21 had not repealed the Majority Act 1875, ought to have taken into consideration of it, and having not done so, has resulted in miscarriage of justice. Para. The background fact of the instant petition is that the marriage between the petitioner number 1 and the respondent was solemnized on 1/2/2013. The respondent instituted a suit under Section 3 of the Prohibition of Child Marriage Act, praying for declaring the marriage with the petitioner number 1 a nullity and for annulling the same with consequential reliefs, as the respondent was born on 11/2/1996 and thus he was a child as per definition of the Hindu Marriage Act 1955, being 17 years 2 months 20 days on the date of marriage, and on the other hand, the petitioner number 1 was more than 20 years of age on that day, that is not a child. In the aforementioned suit, the petitioners filed an application under Order 7, Rule 11, read with Section 151 of the CPC, seeking dismissal of the suit on account of limitation as per the provision of Section 3 of the Prohibition of Child Marriage Act 2006. The aforementioned petition was rejected by the learned trial court, with the impugned order dated 27/2/2018, holding that the suit was instituted within the prescribed period of limitation as specified in section 3 of the prohibition of child marriage, inasmuch as a male attains majority only after attaining 21 years of age and not 18 years as contended by the petitioner. Para. A bare reading of the above section 3 inter alia reveals that every child marriage is voidable at the option of the contracting party who was a child at the time of marriage. However, a petition for annulling such a child marriage by a degree of nullity must be filed in the district court only by a contracting party to the marriage who was a child at the time of marriage and before the completes 2 years of attaining majority. Para. Accordingly, the revision stands dismissed and the impugned order of the learned trial court is affirmed. The interim order stands vacated. Revision petition stands disposed of.